Okay.
Judge, I have two cases that I'd like to present to the court to best articulate our position on everything. I've given one to each of the parties. The cases I'm providing the court are Carter versus State, 1115, Southern 3rd, 1031, and Brown versus State, 132, Southern 3rd, 312. Here's our position, Judge. We have alleged over and over and over again that Mr. Allen is lying. He's lying. He started lying in October of 2018 to try to get a deal. He continued lying in July of 2022 to try to get a deal. He continued lying in this trial for the same purposes, to try to better his deal. The prior consistent statement, only an exception to the hearsay rule, only permits statements offered to predate, that predate the alleged motive to lie in order to rebut the allegation that he was lying because of that motive to lie. And that's what both of these cases stand for. So we have an objection to any prior consistent statements that the state wants to allege occurred either in the October 2018 statement, the July 2022 statement, or his deposition, which I guess they're not seeking to do. Now, Mr. Allen gave two statements prior to that. He gave a statement on the phone the day he was arrested, and he gave a statement the next day to Detective Curcio in person. If the state could point out any specific statement that was made on either of those days, those would predate what we are saying is the date of when he started lying about Mr. Boatwright being involved in this in order to get a better deal. And in that case, the state would have to point to a specific statement that we alleged during trial that he was lying about because he was trying to get a better deal. And this is where the prior consistent statement would come from, because it happened prior to him trying to get a better deal. Over the lunch hour, I went through both of those statements again, and I did not allege, there's nothing in either of those statements that I alleged he was lying about to the jury because he was trying to get a deal. In Carter versus State is a fourth DCA case in which there was a fight amongst homeless people. One of the Carter was charged with aggravated battery on another individual. The defense in that case said that everybody at this homeless camp had an issue with Carter. They didn't like Carter for some reason. At trial, the state got one of the police officers to testify about what one of the other homeless people said happened during the fight, and offered it as a prior consistent statement. And the fourth DCA overturned that conviction because the defense in that case had alleged that the motive to lie, the reason that the person that they were saying that these witnesses were lying, was because of issues that they had prior to the fight. On it begins HN3 of the statement, or excuse me, of the case, which is on page, looks like begins page **7. It's like the fourth page of the actual document I gave the court. Section 90.8012B provides that a statement is not hearsay if the declarant testifies at trial and is subject to cross-examination concerning the statement, and the statement is consistent with his testimony and offered to rebut a charge of improper influence, motive, or recent fabrication. However, the exception allowing a prior inconsistent statement as not hearsay involving impeachment by bias or corruption or improper motive is only applicable where the prior consistent statement was made prior to the existence of a fact said to indicate bias, interest, corruption, or other motive to falsify. Stated another way, a prior consistent statement is inadmissible under 90.8012B if it is made after the witness's motive to lie arose. And then the court goes into the facts as I just articulated them in that case, and overturning that conviction. In Brown versus State, also a Fourth DCA case, this one is out of this circuit, was a sexual battery case in which the question was whether the interaction between the defendant and the victim was consensual or not. The victim came home with a hickey, and the defense alleged that her friends or her boyfriend had seen the hickey, and so she made up this allegation because of that. And the judge in that case permitted a witness, a friend's boyfriend, to say that she had told them that this was non-consensual, essentially. But it was after everybody had seen the hickey. And the Fourth DCA overturned that conviction for the same reasons as well, because a prior and consistent statement is inadmissible if it is made after the witness's motive to lie arose. In our case, we have, on behalf of Mr. Boatwright, I made it very, very clear that we believe that beginning in October of 2018, Mr. Allen testified that he was trying to get a deal. That's why he was cooperating. And it is our assertion that he lied about Mr. Boatwright's involvement, about everything about Mr. Boatwright, because Mr. Boatwright had already been arrested and he was just trying to give police a story that would give him a better deal. And so we object to anything that is in the October 2018 statement, the July 2022 statement, because it does, and none of those statements arose prior to his motive to lie, that being him trying to get a better deal. We also object to anything in either of the July 2018 statements, because there are no statements in the July 2018 statements that I, at any point during cross-examination, alleged, inferred, challenged, asserted that Mr. Allen was lying about, period. Also, that he was lying about specifically in order to get a better deal. I never made that assertion, and so none of those statements would qualify as a prior consistent statement.
Does Your Honor want to hear from all the defense and portion of the state on the argument, or?
You have something to add?
Just on behalf of Mr. Newsom, I would move to adopt the argument of learned co-counsel and further point out to the court, my understanding of prior consistent statement introduction has always been that it can be used to reply to inference of recent fabrication. None of our questions, I think, particularly Mr. Newsom's questions, have talked about any recent fabrications. What we've alleged is that his statements have been not truthful from the very get-go, and they continue to be at this stage. Furthermore, I've reviewed the two statements earlier that we've talked about here to Detective Curcio, and I don't see anything in there, either of those statements, that would qualify as a prior consistent statement, even should the court disagree with the case law presentation and viewpoint of defense counsel, or the fact that we're arguing that fabrication has been continual. He really doesn't say anything in there, either of those two, Detective Curcio, that I think was qualified. I can see.
Judge, on behalf of Mr. Williams, I adopt really the only recent fabrication that I went to get into was the one regarding him not knowing who was driving the car, and we all know how that went, so that's the only one that. Other than that, I adopt the same argument.
I would also add for the record that, the reason we have this is because otherwise, introducing someone's prior consistent statement is improper bolstering, and that is what the state is trying to do. The reason we have the exception is because there are some cases in which the person said the same thing before a motive to lie arose. And in those instances, that testimony should be permitted. We do not have that here. We do not have any statements that we challenge Mr. Allen on that he made prior to the motive to lie arose. And so any introduction of these statements would just be improper bolstering of Mr. Allen's testimony.
Judge, let us know when you'd like us to respond.
Let you know when All right, I'll hear what the state has to say.
So just, we would first argue that, the first statement, which was a phone call after Mr. Allen was arrested, he did give a few statements that would indicate that he's in fact telling the truth as opposed to what all defense counsel has insinuated he's been lying since the start. We can go through those, but again, with the second one, which is when he gets 2 Broward, he's arrested, still no involvement of the state at that point, he's not promised anything. And there, he was impeached, and cross-examined on that statement as well by, I believe, all counsel, or at least Mr. Padilla and Mr. Kimmock. Then on the October 2018 statement with Mr. Lewis present with him, again, no promises were made to him with regards to a plea agreement at that point. He was hoping to get one, but he was not promised anything, and that's what the case law talks about. That's the after a plea deal or a promise for a deal at that point, and I will cite to the case I provided earlier, which is Rodriguez v. State, 57, 3rd, 961. And it talks about, on the last paragraph, it says, further, Deep Tuilio's statement was made prior to her plea agreement, which is what the defense implied provided in order to falsify. We would argue at this point in time that all of these statements have to be taken into context together because of the fact there was a reasonable interpretation from all of the cross-examinations of Allen's entire testimony that was expressly implied that he was lying from the start. But in fact, he does admit to some of the things that he wasn't telling the truth about, but some of the big things were consistent throughout each statement that he gave, including his testimony. That the defense tried to cross him on, impeach him on something. I would argue that specifically today with Mr. Ramirez, he went into some of his statement from 2018, October 2018, and Mrs. Shields' statement with him, where in fact some of the impeachment was read incorrectly, and as we were going through some of the impeachment, it was read incorrectly, and it was taken out of context, and he was asked a specific question to insinuate he was lying, when in fact the actual transcript shows that he further explained himself within those transcripts. So again, with the 10-23-18, no plea agreement was made, it was consistent. And then again, Mr. Ramirez just admitted, as he's arguing to Your Honor today, that Mr. Allen's been lying since day one, and that's what they've been trying to insinuate with every question they're asking. However, no plea deal was ever given to him until after Mr. Shields took a statement from him. I know with Mr. Kimmock, I do have some of the cross-examination impeachment questions that were asked. One of them, just as an example, I just have it. One of it was about, I think it was about Dietrich renting the car and him being asked when Mr. Kimmock that you had no idea, and he says, no, I was fully aware. He then asked in October of 2018, did you say something different? And Mr. Kimmock says he didn't guess, he knew Dietrich rented the car. So he's being impeached on things like that, which when you take into context the rest of the statement, is in fact still consistent with what his prior testimony was.
Judge, one of the objections that I had levied was that we don't even have his direct examination, which I believe for this hearing would have been crucial to have it. We don't.
All right, let me do this. The phone statement is the first one, correct?
Yes, sir. Yes. July 25th.
And am I right in understanding that this is before any discussion of,
Yes, we have.
this is prior to,
I did not allege in my cross-examination that Mr. Allen was attempting to get a deal during the.
okay. So let's go through this one and state what in this would you seek to bring out?
So Judge, just going page by page, obviously the first page is just really context, it's not to provide which statement this is really, to understand that it's a phone call while he's still in Georgia.
I object to that. It's a statement and just say it's context is inappropriate.
Your Honor, I'm not done speaking.
Oh, sorry,
So can you
I'm sorry.
speak once I'm finished addressing Your Honor?
That'd be nice.
So, within that context, later on, it goes to, we would obviously, again, also ask for the Miranda to be in there to show that it was a freely and voluntarily given statement. But then on page 4 at the bottom, the last question, okay, Chucky, how long have you known Chucky? Not that long, it's been a while. Then it goes to page 5, well, how many months or years? A couple of years. And then a few questions down, it starts with, all right, so you know well enough that he tattoos you. We would actually agree to get rid of the majority of that question, only because it's really Detective Percy just testifying, but the actual question within that paragraph, do you remember that day going up to Riva to Chucky? Yes, sir, yes, yes. Obviously get rid of the phone breaking up, things like that. And then the next question we would ask to come in is a few lines down. Well, I'm going to tell you as it goes on. I'm telling you, just basically I'm leading up to what happened that day, so we understand what case we're talking about. I was just asking you who was driving the Dodge that day. Chucky was. Chucky was, okay, yeah. And then again, we'd ask basically the rest of that page to come in.
Well,
Sorry. on to page 6, question that says, yeah, when, where did you first get into that Dodge journey? How did you end up getting in the car? Answer, he actually rented a car through his sister. I know this is unintelligible, but listen to the audio. Then further down on that page, the third to last question. I mean, I know the answer to some of these questions, but I got to ask you just to make sure I got the story straight from the people then where I'm talking to. What's his sister's name? Answer, Tony, I think. Question, Tony, all right, so that morning, you guys spoke to Riva, who got the Dodge Journey? Do you have it and you pick him up, or does he have it and he picks you up? Yeah, he called me to pick him up. Next page, on 7, the first question, okay, now over there by what they used to call the driftwood, that's where you were staying on 17th Court by your mom. Yes, sir. And then skipping that next line, going to the next question, you get up to Chucky's house in Pompano that morning before you go to Riva. Yeah. And then you got to understand, I know the answer to the question, so I'm just trying to see how truthful you are being. Answer, I know, but it's like I'm putting myself in a situation, I don't have a clue what's going on. And then the last question on that page, who gets out of the Dodge? I'm kind of asking you, I didn't get you in trouble with your friends, kind of got you in trouble by what you did. So I'm asking you, you know who they are, but if you don't want to tell me right away, we'll get back to that. So let's get back to you go up to Riva, just without saying their names, how many people are in the Dodge Journey? You, answer 4. Question, Chucky, all right, so there's 4 total, you, Chucky, and 2 other dudes. Yeah. That was it, Your Honor, in that particular transcript.
Are there any specific objections to those areas?
Yes, Judge. None of those statements are being offered by the state to be charged with improper influence or illegal fabrication. I never, ever alleged or asserted or insinuated to Mr. Allen that he was lying about any of the topics that the state just brought up when he testified at all. I never challenged him that Chucky Diedrich was driving the car. I never challenged him that that Chucky had called him to come over there. I never challenged him about his sister's name being Tony, or that Tony had rented the car. None of these statements that I challenged him on or alleged that he was lying about those things to the jury because he was trying to get a deal. And so the only thing that bringing those in would do would be to improperly bolster his testimony. Because they're not being offered to rebut a charge of improper influence more than the recent fabrication, they do not qualify as prior consistent statement.
I agree. I don't see anything there that would qualify as a prior consistent statement that is in any way material to the testimony of cross-examination, particularly not to anything I asked about.
Judge,
Other people in the car. Okay.
and just to follow up, for example, if I had challenged Mr. Allen that Diedrich was driving, if I had tried to allege that he was lying about Diedrich driving because he was trying to get the deal, then this statement would absolutely qualify as a prior consistent statement because
I understand your argument.
right? You don't have that here. I never did.
Judge, the only difference between my argument and their argument is that at some point, I did say you rented the car. I told them that. So everything else still applies to me, to my client, with that caveat. But other than that, like, I didn't say that he was a car when that day. There's some, during his testimony, there was issues that I brought up regarding afterwards, but specifically regarding him driving the car, I didn't challenge that.
I understand everyone's arguments. Let's move on to the next statement.
And Judge, just for the record, we do have the transcript for this previous cross, and I guess it would be on page 28, but going into the next page where there's no page number. He's cross-examined on Mr. moving the car.
I'm sorry, I didn't hear that.
Page 28 going into the next
I
page.
just think we set up to it.
You cross-examining him on being in the car, being in the car and driving, Mr. Williams being in the car and driving.
Because that whole line of questioning, Mr. Padilla is saying that Mr. Williams got out of the car and that then Mr. Allen was the one that spearheaded everything from that point. So there was a challenge as to that.
The next statement would be the 7/26/2018 statement. The first page we would go to. On page 11, it's really just Miranda, but for purposes of showing the voluntary statement, that goes on page 12 and 13. And then on page 14 at the bottom, so I mean, that's where I kind of wanted to, on page 15, start the story up. I mean, you already told me you were there. It's obvious I was there. And then to line 14, I mean, I'll start slow. The guys that were in the car with you, other than Chucky, how long have you known them? Their whole life, 4 years. Not that long like years or months. He says months. All right, well, I mean, the question is, what do you know about them? What's their name? What's their nickname? Black question mark, Blackie question mark. And then, on the next page,
You're on 15 now, sorry.
16 at the bottom. We're on double 2 next. But you don't know the other one when you talk to, what does Blackie look like? What does he look like, height, weight, short, tall, big, small? No man can be tall. 17, you would say that line 1 through 12 would also come in, and that's because one of the attorneys questioned him on stating that he didn't provide the names of Mr. Newsom or Mr. Boatwright, but in a sense, he is giving them the information on them, and he was impeached on not actually giving up their names. That's all we have for this statement. October 23rd, 2018.
Okay.
So page 3 will simply be context, show which statement it is. Oh, sure. Council should ask for a second to pull up that. Page 4, nothing. Page 5, line 15 through 23. Where he identifies Chucky and calls him Dietrich. So that's who Chucky is. Then on page 6, line 22 through 25. And page 7, lines 1 through 2. Then line 17 through 22, or sorry, through 25. No, I'm sorry. No, 22, sorry. Page,
Is it 17 to 22?
sorry, yes, 17 through 22. Page 9. It would be 1 through 19, however, we would take out the fact that, on line 7, that he said he has a license, and because that would insinuate that the others don't, so we feel that should not come in. And then line 20 through 25, we would have the part in with Detective Curcio of just the
Wait a
question.
minute, go back on page 9,
Yes,
say this again, 1 through,
1 through 19, other than the statement that Mr. Allen says that I have a license.
I think he already testified to that, didn't he? I think he already testified, one reason why he was there is to get a license, and he did it, so.
And that's fine. Then the line 20, where Detective Curcio is speaking again, that also would be with it says that Chucky didn't have a license, so I was saying that that should come out, but then the actual question of who asked you to do it, Chucky or Tony, Mr. Allen says Chucky, so just taking out that Chucky doesn't have a license. All the way on page 10 up until line 16. Then page 11, line 1 through line 9. Then line 22 through 25. And on page 12, line 1 through line 4. Line 14 through 25. Page 13, just, first line is line 1, and then skip down to line 5. Here, he says, who do you go pick up first? Through the rest of the page.
You said like 5 or so?
Line 5, where Detective Curcio says, who do you go pick up first? Through page 14 to line 11. And that was the discussion of the example I brought up before with Mr. Boatwright, being at his house or not, and being impeached on that thing. Page 16. 14, line 13 through 19. Line 17. Page 17, line 15 through 25. Line 18, sorry, page 18, line 1 through 5. And then at the bottom, line 25. Until page 19 through line.
Sorry, back on 18, 1 through what?
1 through 5, and then 25. Into page 19, up until line 5. Page 20, line 5 through 14. Page 21, lines 22 through 25. And then on page 22, line 1 through 19. Page 23, line 18 through 25. Page 24, line 1 through 9. Page 25, line 5 through 15. This is specifically the area with Mr. Ramirez's questioning, so we felt the whole line of questioning wasn't put into context properly.
Judge, can I speak to that just briefly? I mean, if they thought I was incorrectly quoting what was in this, a contemporaneous objection at the time would have been the proper way to handle that. Or later on, simply ask him to go back through it, but it's not. This would not qualify as a prior consistent statement. That would simply be redirect on issues that were brought up on cross.
Your Honor, he was impeached in asked, and Mr. Allen was only shown the part that he was supposed to read as to what it was, so he's admitting that he lied, when in fact he actually goes on to say what he actually saw. So.
Clearly showed him the whole page.
You told him the lines to read.
I told him the ones that I highlighted that he could look at, but he had the whole page in front of him.
Your Honor, Mr. Ramirez is standing up there, reading the lines.
I was good.
He indicated when he was being questioned about he said he never saw a necklace, when in fact he did see a necklace, and he's like, he remember what it looked like. I don't know the actual word, but he said it was kind of thick, metal medallion on it. He didn't go through that whole section of questioning. He only went to, I believe, line 10. But at the bottom of page 25, line 23 through 25, page 26, line 1 through 21. Line 12 through 23. Line page 28, line 13 through 25. 29. Page 29, line 17 through 23. Page 30, line 1 through 6. Then line 10 through the bottom of the page. Page 31, line 14 through the bottom of the page, line 5. All of page 32. Page 33, line 1. Line 7 through 12. Line 16.
Can we just have, for instance, the one you're on right now, page 33, I'm struggling to understand what you're saying, how that in any way would qualify under what you're asking for. It appears to me that you're just trying to get back up there on direct and fix things that were impeached on cross. Nothing here could have been brought out on your direct, and nothing in what you're talking about was challenged by me in any way.
Judge, we have 3 different defense attorneys here, or 5 different defense attorneys.
I'm getting, I apologize, I'm getting lost when we go through all these sections, and I would point out also, in 3 or 4 of these already, there are inconsistencies that we never brought up. And if they open this door to that, we're gonna go back to. So in terms of funneling down on the testimony of this witness, it would appear that the major reason they're doing this is because they don't like the way the crosses came out, and they want to go back into things that have already been dealt with. There are areas that are nowhere near directly rehabilitating in any way, and open the door to more inconsistency.
I thought Your Honor wanted me to just go through.
Keep going.
Go ahead, keep going. I wasn't trying to stop you.
Well, I was stopped, so.
I know, I'm just trying to make
All
a
right,
point.
just
If you could tell me what you mean.
address your comments to the bench, not to each other.
Sorry.
Thank you.
So line 33, page 16. Through line 21.
Page 33, like 16 to 21.
Yes. Line, page 35, line 20, where Detective Curcio starts saying how many you like all one night there, or you went into a motel and hit you. Line 25, into page 36, line 3. And then at the bottom of page 36, actually, no, check that on that. And then page 39. Page, or line 10 through 25. Into page 40 until line 14. Line, page 41, line 12 through 19. line 5. Through the bottom of the page. I'm sorry, until line 24 now. Sorry. Page 53, line 6 through 22. Then page 58, line 8 through 25. Into page 59, so line 17. Page 63, line 8 through 24. Into page 64, line 1 and 2. Page 67, line 4 through 8. And then line 21 through 25. Page 68, line 1 through 7. And then all of 69. Page 78, line 5 through 16. Page 88. No, I'm sorry, not page 88. Page 96, line 7 through 25. And then page 97, which is line 2. And that is it for that one.
And
And this page 7, line 17, which is Mrs. Schultz's question of why did you guys go there in the first place? Through line 24. Page 8, line 9. Through 25. Page 9, line 1 through 7. Judge, we're making copies of some of these for council, and my highlights have seemed to, some of my pages have seemed to have gone missing, and we're making them, so.
Oh, let's hold off on this part. let's go in reverse order. Back to the statement that was made on July 28th. Is it the state's position that this statement is not made by anyone at this stage in trying to work out a deal?
I would think that anytime anyone speaks to law enforcement or anyone, they potentially want a deal, but it's like, promise a deal that a deal is made.
Well, I know that argument can be made, but I'm just, let's break it down as to each one. At the point that he's meeting with the prosecutor and he's got his counsel there, this is a proffer before discussion, right?
Well, I was there, so I can speak to that. No, not correct, because he had previously given a statement. Going into it, I knew, and I'm speaking in first person because I was the person that took the statement, that at any point, because he had maintained he was not guilty, he had a trial date set, and that he could just end up deciding, I want to go to trial. So it didn't put me in any position to negotiate with him anything. And I also made it clear, I think it's on page, it's at the beginning of the statement, I don't know if you have it, where I said, page 6, starting on line 16 through 25, I haven't made any promises to you because Mr. Lewis, well, Mr. Lewis is not here, but Mr. Lewis, who was present at the time, I made it crystal clear. There are no promises, there are no deals. If you talk to me, you are just talking to me at your own volition. This statement is just something that you are willing to give on your own volition, and we could end up just going to trial and he could be sitting at the table with his co-defendants. That's what I believe, and that's what I believe I communicated on page 6. And this whole thing about whether or not there was a deal, the state still maintains there was not a deal. To me, my understanding is that it would be negotiated.
Yeah. But the idea is not, you don't have to have a deal in place. You have to show his desire to have a deal in place or to make a deal. And I'm reading your statement on page 6, saying, I've made no promises in terms of years or anything, right? No, ma'am. In terms of years, all right? And you understand as part of you giving a statement today, and ultimately when you resolve your case, that you'll be added as a state's witness. Yes, and that means you'll likely be deposed by your co-defendant. The court has no way to interpret this other than, even though the terms aren't set out, that this is done in anticipation of trying to make it.
I understand what Your Honor is saying. I can only speak from first person because uniquely, as opposed to any of the other statements, I took this statement. And I still maintain, because the only thing that I was willing to do then, and that I maintained, is that if he wanted to resolve his case, they would have to plea open, which technically is not a deal with the state. I'm not giving him anything.
They're not saying that there has to be a deal. They're saying, what is the witness's motivation to testify or to give a statement? Okay? And if there's a question about it prior to this, there's no question at the time that they go in there that that's what he wants, whether you've given it to him or not.
Okay.
All right? Now, let's look at the other extreme, which is the first statement that is made over the phone while he's, I guess, still out of state. Okay? And that one, I think the defense has conceded, at least at that point, no deal making has been done at that. So, I mean, those are the two extremes. It's the ones in the middle that, I guess, the one in the middle, which is October 23rd, 18, which has majority of what you've set out here.
And Judge, if I may, just the second statement, in that statement, he does ask for a lawyer at certain points because he's unsure of what to say or how to go about it. So if Your Honor is potentially considering that the October 2018 statement was also regarding his deal, it was, I would argue that it was more so because he had asked for a lawyer in his prior statement to have assistance in how to answer these questions.
I got that. Again, the prohibition against prior consistent statements really comes from the unreliable nature of hearsay generally, and here the defense is impeaching, if you will, by saying, look, you were trying to save yourself and you were making statements in furtherance of that. Whether or not you're offering him anything, whether or not you, even if the recipient of the statement isn't thinking, I want to make a deal with you. So what's he thinking at the time? Is he trying to make a deal? Is he trying to offer up something that will be interesting to you? So I have real difficulties with that. On the other hand, I also just have real difficulties with the fact that, given the number of statements that were made and the way in which the defense picks out at random small portions of an overall accounting of what happened, and so here's a lie, here's a lie, here's a lie, and yeah, you know, witnesses admitting that there are lies in there, and the suggestion being made by the defense is the whole thing is a pack of lies, when he's admitted to some and not to others, and there are some consistencies throughout the stories, and you know, trials a search for the truth. We're trying not, I think either side wants to mislead the jury. I do not think that it is wise at this point to bring in redacted statements or tapes and play them. And again, if we did so, it would have to be with the limiting instruction that these are to rebut suggestions of recent fabrication or trying to curry favor. And I'm wondering how much of this can be cleared up on redirect through questioning without bringing in statements. Because I think from the same statements, you can ask him, well, you indicated you were lying about some of the things, but you did tell them that they were all in a car. You did tell them these things. I mean, I think those may be properly correct without pulling out the text of statements. And that way it's clarifying, and even in sections where, for example, where you thought Mr. Rare showed something that didn't have the whole thing, you come back and say, well, counsel asked you about this, read the rest of that. Does that refresh your recollection? What's your more complete answer there? And I think it can be tied up that way without playing for them what purports to be the entirety of the statement, but which in fact is also an edited version.
Your Honor's ruling is that none of the prior consistent statements can come in? Not one?
Well, perhaps that first one, which they've conceded to, but there's not much there. I don't know that you really want to bring in the fact that they got the car from whoever. I'm not even sure that that's been attacked on that. I mean, defense, you agree that on redirect, the state could clarify that you did in fact tell them, you know, you've maintained all along, these were the people that were there, that sort of thing, yes?
It's the only way I've ever seen it done, Judge. And it's done that way very effectively by many prosecutors. Unfortunately, the facts are the facts here. And I understand why they're a little concerned with the way this went, but you can't.
Well, I
redo
mean,
everything 'cause
see,
you
part of
put
the
it
thing with
away.
rehabilitation is, this is, you know, none of these cases directly answer the question that we have before us, because a lot of the case law, there's one prior statement, there's not like 4 of them. And the state might be able to argue that the motive or the recent fabrication doesn't exist on this one, but it might exist over, you know, they're kind of, it kind of interlocks in ways. He may have had motive starting, you know, pretty much at the point he arrives in Broward County to get himself out of trouble, okay? And it progresses in degrees as it goes along. Secondly, when we talk about rehabilitation, most of these cases involve someone getting caught making a statement, and then the prior consistent statement helps to clarify that, no, they didn't just make this stuff up. The witness has already admitted, I lied about that, I lied about that. So I don't know how you rehabilitate when the witness themselves has said, I lied about that. There is no rehabilitation from that. He's already admitted that that's a lie. What the rehabilitation comes from is redirect. Well, let's talk about what's not a lie. And did you tell them that? And you were informed of that. So I think that can be done without getting into these statements as prior consistent statements. It's redirect. It's pointing out the differences between his lies involve him taking himself out of the picture, but the rest of the story remains consistent. And I think that can be brought out, not objectively, on redirect without playing these things and impermissibly bolstering through recorded statements.
And Judge, I respectfully think that I disagree on understanding the court's ruling with regards to saying he was consistent about this part. The only thing that the state can bring out that he was consistent about is something that A, predates the motive to lie, and B, that I challenged them and said, you're lying about this now because of your motive, because you were trying to get a deal. And in the July 2018 statements, there is none of that. I never challenged this witness on any of those statements. And so I don't think that the state can just say, you know, you were lying about this stuff, but you were always, even in July of 2018, you were consistent with, you know, this, whatever it is that they wanted to do, because I didn't challenge any of those July 2018 statements.
I know that Mr. Kimmock and all of the defense counsel respectively have made the argument to the jury and outside of the jury's presence that they're representing each person separately. That's understood. However, Mr. Kimmock's argument obviously doesn't address for us that Mr. Padilla did it or that Mr. Ramirez did it on behalf of their client. So we, the state, can't separate it that way. I haven't been afforded the opportunity to rebut or do redirect after each cross. I have to wait for all of the cross examinations to finish in order for me to address everything over the last couple days. So it is impractical for me to even address it that way, in the way that he's saying, well, I never said July 7th. If that was the case, then we would have had 3 separate trials. We've had these trials together for a reason. And the reason that I believe I can go forward and say, well, this is what was attacked, not necessarily having to specify when Mr. Kimmock asked you or when Mr. Padilla asked you, because it's inextricably intertwined. He's saying all 3 co-defendants were there. He's saying it was consistent from whatever date. I should be able to address it that way. Otherwise, then we would ask for your honor to reconsider your ruling regarding the prior consistent statements, because it's just impractical the way that I guess the expectation for me to do this redirect. I mean, it's just, I've never heard of anything like that before. And the other thing is, you know, I still would have been, even if your honor ruled that we could use prior consistent statements, I still would have been afforded the opportunity to do a redirect. It's not an either or.
No, of course.
And because I think that there's some counter argument like, oh, well, you know, they're trying to rebut it. I'm entitled to do a redirect regardless, okay? This is an additional area that's well established in Florida law that allows the state the opportunity to be able to enter this rebutting information and testimony because of the way they cross-examine. We wouldn't ordinarily be allowed to enter it. But this is how they chose to cross-examine. This is how it came out. So we are now asking the court to allow us that opportunity, because what I haven't heard from the court, I understand your honor saying, well, if we were to, you don't want to have it bolstering, but it seems like I haven't heard from the court. Did we not meet our burden to use it? Because I thought before the.
Yeah, pretty much, because here's the problem. And
Okay.
again, there are plenty of cases that say you can bring in prior consistent statements to rebut recent fabrication or motive or you know, bias thinking, all these things. But all of them are pretty clear that the statement has to be made prior to that motive or that suggestion coming up. And if we look at this and what he says, what he testified to was, yeah, he was interested. Whether you guys were offering him something or not, his motivation was he was interested in minimizing his involvement to make the best deal possible for himself. So under those circumstances, there are a lot of cases that just warn about the dangers of allowing that in. And so I've made my ruling. We're not letting in the text of prior consistent statements. But what I was saying after that is there's nothing in that prevents you from doing an effective redirect examination.
So am I going to be allowed latitude to leave then on some things? Because then.
Well, you're going to be given latitude to not be straying into all sorts of areas. And although you don't have to identify each time, I think it is helpful and to address Mr. Kimmock's concerns when if you say, well, Mr. Raris mentioned this, and you know, you can, if you reference that helps narrow it to whom it's addressed to. But yeah, if it was kind of done all at once, and so you're getting your one, and not 3 opportunities, but it's going to have to be through the redirect process and not through the playing of prior statements.
Okay.
So, thank you.
10:30 tomorrow?
Yes. Unless Mauricio does something that gets Cohen to come in here again.
Sir?
I said, unless you do something that gets Brad Cohen to come in here again.
Oh, yeah, for sure, I'll come back.
Yeah, you can leave.
He wasn't nodding off. He was still able to answer questions.
And because you know that this is going to be played in front of the jury, during the course of this interview, you humiliate him, don't you?
Again, anything I said to him or my demeanor or my questions were all meant to influence him.
And those are interrogation techniques.
Yeah, some of what I do is an interrogation technique, of course.
You made fun of him, right?
Can you explain how I made fun of him?
Who's going to pay for your Chick-fil-A? Remember saying that to him?
Yeah, that's not me making fun of him. Chick-fil-A habit, sadly, is the problem I have to pay for every day. I have a teenage daughter that routinely goes to Chick-fil-A, so my example for someone that doesn't have any money in their bank account just fell back on my own experience.
That wasn't you commenting on the defendant being overweight
Not at all.
or being lazy,
Not at all.
because you called him that too, right?
I don't recall.
All right. And when he mentioned that his dad had a foot problem, you said, well, now you both have foot problems. Remember saying that?
Yeah,
That's kind of a snide remark, wasn't it?
Well, I was pointing out that you've been shot in the foot. Now you both had foot problems.
That's making fun of him. When you asked him what his sister's passcode was to her phone, you said, is it daddy's favorite number 1? You said
Right.
that, right?
Right.
You also said to him, what are you hoping to get a job being the number 1 guy on Halo? You said that to him too.
Right.
To let the jury know your disdain for him, right?
That was not to let the jury know my disdain for him.
Because you know you can't do that on the stand. You know you can't give your opinions on the stand, right?
I give my opinions all the time on the stand.
Not as to the defendant's guilt or innocence, you can't. You know that.
Yes.
And the beauty of it is, throughout this entire interview, it doesn't even matter what he says. You've made him look guilty just by the way you ask questions, right?
Well, again, you know, the conversation is between the investigator and the person you're interviewing. Everything I do, everything I say is meant to elicit answers from him, you know, get you to tell your side of the story, get you to tell me things, get you to convince me how things really happened. I mean, it's really the same for every interview.
But you know that your questions aren't evidence, right? You know the jury will be instructed that what you say isn't evidence. It's what the defendant says that matters, right?
You may.
All right, Mr. Johnson, go ahead and ask another question.
Thank you. Maybe you don't know what the jury will instruct. But the jury will have seen your reactions and your questions just the same, right?
Yes.
They'll see that video.
Yes.
And when you told us that you try not to lie to people when you're questioning them, there were a number of things that you said to Alex that weren't true, right?
Yes.
You said to Alex, you told the 911 operator your mom and sister were dead.
I did.
He never said that, did he?